morning, everyone. Welcome to our March Lunch and Learn for the ADR section of the Florida Bar. Thank you for joining us. This is our third Lunch and Learn in this series with Gary Rosner and Gena Abel-Barnes. My name is Megan Moschel, and I'm moderating this program today for the Alternative Dispute Resolution section, of which I am the chair of the CLE committee and member of the Executive Council. I'm moderating this program today with the help of Christina Acosta-Blunt, who is our incoming CLE chair for the 2026-2027 year. So thank you for helping me out today, Christina. If you are not a member of the Alternative Dispute Resolution section, I encourage you to join this dynamic group. Our membership is comprised of mediators, arbitrators, and attorneys who participate in various forms of dispute resolution. The Alternative Dispute Resolution section offers valuable resources and networking opportunities with others who are leaders in the field of ADR. We'd also like to thank our annual section sponsors, Miles Mediation and ADR Notable. First, some housekeeping matters. If you wish to ask questions of the speaker or need technical assistance, please utilize the chat feature. The presenter will answer all questions at the end of the program, although they may answer some questions throughout. You will need to log on to the Florida Bar members portal to enter your own CLE credit. But first up today, we have preparing for a business divorce mediation. I'm going to give you that CLE number. Don't worry, I'll give it again at the end. But for right now, if you've got a pen handy, it is 2517052N. And then our next program at 12:30 is Therapy Speak at Mediation with Gena Abel-Barnes. And that CLE number is 2517053N. So our first program is going to count for 0.5 general CE and 0.5 in business litigation certification area. And our second CLE is going to count for 0.5 general CLE and 0.5 professionalism. This course also qualifies for CME credit, which does not require a course number as it's self-reporting for the purpose of renewal of mediator certification with the DRC. And at the end, I'll kind of go over what you're going to have to put in those course renewal forms in order to get credit for this program. But for now, I'd like to introduce our first speaker, Gary Rosner. Let me go ahead and stop sharing my screen here so you can see Gary. And Gary Rosner is a seasoned litigator and respected dispute resolution professional with more than 25 years of experience handling complex civil matters, including commercial, real estate, probate, business, and title litigation. A Florida Supreme Court certified circuit civil and county mediator, qualified arbitrator, and Florida Department of Financial Services mediator, he's widely sought after as a mediator, arbitrator, and special magistrate. In addition to his practice, Gary serves as an adjunct professor of law at Nova Southeastern University and is an active leader in the legal community. He holds numerous board and committee positions across the state and local bar associations, including service on the Florida Supreme Court's Mediator Ethics Advisory Committee and the Executive Council of both Florida Bar's ADR section. His professional recognitions include multiple top lawyer honors and an AV preeminent rating from Martindale-Hubbell. Thank you so much for being here today, Gary, and please tell us more about mediating business divorces.
Okay, thank you for having me here, and thank you all for taking time out of your day to spend time with us today. I'm going to get right into it. Thank you for the introduction, Megan. So let's just talk generally. What is a business divorce? A business divorce is the legal and practical separation of business partners, co-owners, or shareholders due to irreconcilable differences. It may be breach of fiduciary duties. It just may be a difference in opinion of where the company should go. Types of issues that cause business divorces. Sometimes we see it a lot when a family member, maybe dad or mom and dad own a company, pass it down to siblings, and the siblings have a very different idea of where the way they see the company should go. Sometimes, unfortunately, we see breach of fiduciary duty. Maybe someone's unfortunately taking money, embezzling, all types of issues that can come up. While you see these quite often in partnerships, you will also see them all the time in LLCs and corporations. Generally, though, privately held. You're not going to see these as much in terms of a public corporation. Gets a little bit more, although that can happen, a little bit more complex in terms of how that situation goes due to securities laws, et cetera. But we see this more and when I say smaller companies, it could be a company doing $1 billion a year. This happens to be a family business. or two people blew up a business. They started a business and it just took off and it blew up into a major operation. So let's talk a little bit about the timing of mediation. And if I'm talking a little quick, we have a half hour, and I could do this probably for parts of this as a multi-part CLE. So I'm going to broad stroke some areas. If anyone has questions along the way, just pop them out. If at the end you didn't get your question in, I've already told Megan she can give my cell, my email, and my office line. Feel free to call me. I'm happy to speak with anyone that needs any assistance or has questions on what I present today. So timing of mediation, very important. What I find with business divorce mediations is going to mediation early, if prepared, and we'll talk about that in a moment, creates a significant benefit. Because when a business is having this breakup, okay, if it's whether it's 2 people, 3 people, 4 people that are the shareholders, members, depending on the type of corporate entity, you're going to run into a lot of risks. And the risks are, one, risk of losing clients, okay? Company starts, clients get the feel, it always comes out. Clients start hearing the rumors that, there may be trouble. Partners are having it out. There's issues between the partners in terms of one partner saying to a client, do this, the other is saying you can't do this. And that sense starts to go out that, maybe this company's not going to be around. It can affect a lot of things. Other than clients, it can affect vendors, credit lines. If you have credit lines, maybe banks or whoever's providing the credit lines to the company, they get nervous. They start hearing, is this company going to go under? Okay. You have reputational damage potentially. If the partners go at it, or the shareholders that are involved in the breakup, all these factors come in. And what ends up happening is, unless you're going for a dissolution of the company where both parties say, look, we just want to, get rid of this and we both want to go our ways, those things are going to matter. Those issues are going to matter to whoever's going to either stay in the business or whoever may go out on their own. It's a reputational issue. And it's what you're doing is you're airing dirty laundry, okay? It's taking like a divorce, but a business divorce, and now everything's going out there. Unlike family divorces, dissolutions, where you go on the clerk's website and those entries are sealed, except for the attorneys of record and some others. In a business divorce, it's going to go right on. If it's in circuit court, in the General Circuit Civil Division, those records are going to be available. And all the accusations that are being made against one another, they're all going to be out there for anyone to see. So big benefit to early mediation is you go to early mediation, potentially you can stop all those types of risks that would hurt the company, hurt the reputation of the shareholders, partners, and you're getting rid of it early. The other big thing, as we all know, is for those that litigate these matters, it's an expensive process, okay? Once you get into litigation, you face the risk of a receiver. I'm sure everyone knows what that is. Essentially, if the parties can't agree or there's going to be some type of windup, essentially what happens is someone's going to be appointed a receiver. Court judge may appoint a receiver, and you now have a new president of your corporation or LLC or partnership who's going to come in and say, that's nice what everybody wants, but I'm in charge now. The receiver, as we know, is allowed to, I've acted as a receiver. You can actually hire your own attorney. You can hire a CPA. It's an expensive proposition. And depending on the size of the company, a receivership can be a death knell, because by the time the receiver's done doing what they need to do, those fees could be so high that at the end of the day, whoever won may have won on paper, but there may not be enough left. So that's always a risk. And as we all know, litigation is expensive. It's costly. You're most certainly going to get into business valuations. You're going to have forensic accounting, depending on the accusations that are being made, may determine how difficult, and how detailed those forensic accountings are going to be. So those are just some of the benefits. And like I said, I could go on with that in terms of early mediation. Now, let's talk about the preparation for a successful mediation. And having mediated many of these, more than I can count, I can tell you The ones that resolve are the ones that the front end work is done before we even officially convene for the mediation. And what do I mean by that? In order to get when I do a business divorce mediation, one of the first things I'll affirmatively ask the parties is, have financials, have audits been exchanged? Have liabilities, any outstanding liabilities? Do we have the operating agreement, the shareholders agreement? Has everyone exchanged this? Does everyone have access? I'm sure everyone has seen companies. Sometimes you have what we call the inside person who's actually running the business. And sometimes we have the outside person who's actually out doing the sales, getting the new business, servicing the customers. I see that quite often where we have a divide in responsibilities. Do we have an inventory, physical assets, physical property? Is there a building that not just that if it's John Smith, Jane Smith, Inc., do they also have, if they're operating the business, have they also formed another company where maybe it's John Jane Holdings and there's actually a physical building that's owned that the company's paying rent to that also has to be discussed? How are we going to deal with that property? Okay. So you want to get a handle on receivables, assets, the operating, like I said, and shareholder agreements are critical. Are the tax returns up to date? Tax liabilities, any account, any of that? Because when you go to mediate this for the mediator and for the parties, how do you make a decision on what you may or may not be willing to do, whether it's going to be a stock redemption, a buyout, a dissolution? How do we figure this out if you don't know, if the parties don't know what it is that the company is actually worth, their net worth and their liabilities? And I know sometimes people will say, well, I'm running the business. I know. I can't tell you how many times you say these documents get exchanged. And when we get into mediation, one party may say, one of the shareholders or partners says, wow, my partner's been spending $50,000 a month on food expenses. I always just figured he or she was the inside person. I didn't know they were spending that. I just figured, business wouldn't be, when things are going, to put it the best way is when things are going good and everyone's getting along, generally speaking, people aren't going to be looking as closely. Like I said, especially if you have a setup where there's a more inside person running the day to day, and then the outside person is out possibly courting business, servicing business clients, and bringing in the new clients. The valuation analysis, you're going to want to know about capital accounts, distribution history. Has there been someone cutting checks, depending on the number of people involved? Is someone cutting checks and one of the parties say, I never looked. I just assumed that whoever the manager was or the partner or member that's getting distributions, were they the ones that were saying, well, I'm going to cut a check to so-and-so for 10,000 distribution, but you know what? I think I'll take 15. I deserve an extra 5. And maybe the person getting 10 doesn't really look at it. They just figure, you know what? This is what I got. And I know it may sound, say to yourself, well, who would run it? It happens in business. Okay. I see it all the time in mediations where one partner will say, well, I trusted him or her to run the business while I went out to service clients and bring in new clients. So it does happen. And that's why it's very important when you're mediating these cases, you go over these types of items with the attorneys ahead of time, because not only is it going to be a benefit to their clients, but as a mediator, it's going to help you out quite a bit. Because when you're trying to facilitate a settlement and someone says, well, we haven't done our taxes. We're on extensions for 2 years. We have no idea what the tax liabilities are. It's a problem. I can tell you in some of the mediations I do, the parties will have a CPA firm. If all the people involved, if all the sides are comfortable, obviously one of the best things is you call the CPA. The CPA gets everything up to date. And you don't need to go and hire your own forensic accountants to do that work, okay? I see it often where they say, look, we're very comfortable with our CPA. The CPA, he or she did nothing wrong. This is a dispute amongst ourselves. Another aspect that has to be considered prior to coming into mediation, especially if you're dealing with tangible products or corporate name, is any intellectual property that the parties have. So there may be a trademark, a patent, copyright on something that can become a big stickler because one of the parties may say, look, I'll give you an example. I mediated it was a company that produced certain types of garments. And it was very important to both the two shareholders. They both wanted that trademark. They wanted to be able to continue because that trademark had been around forever and people knew it. There was a value to it. We were able to work it out, but really that was one of the stickiest issues is why should I have to go and create a new trademark when everyone knows this, okay? It's like it, and it wasn't obviously, it was not Nike, but I'm going to use this as an example. If I put a swoosh up on the screen right now and I ask everyone on here, do you know what brand that is? I'm willing to bet that 99% of the people on here are going to say, oh, that's Nike. There's a value to that. Okay. In this particular company, it was a sort of niche product given to a niche group that they were marketing to, but that symbol that they had was known and there was a lot of value to it. And what ended up happening is there had to be more compensation to the other. And what we ended up working out was sort of a twist on that label of what they were putting on the clothing so that both of them would have it. And, there was a explanation that they agreed to verbatim if anyone said, why is one not the same as the other any? Okay. So there were things that were worked out. But like I said, that is a critical component is the preparation in any mediation being prepared. But in these cases in business divorce, because of the numbers, the liabilities, generally you're going to want indemnities, disclosures as to, sometimes you have a case where one of the partners went out on their own, opened a credit line, didn't tell the other partner. Okay. If you don't have all this information, very difficult cases to mediate. If you have all the information, I find generally these cases are resolvable. Obviously, when there's what's seen as untoward conduct by one of the parties, makes it a little rougher, as we all know. When emotions get involved, again, that's on the mediator and the attorneys steering the client back to making a business decision. If there's allegations of embezzlement or diversion of corporate assets or waste of dissipating corporate assets, a little bit tougher. But if it's just a philosophical difference between the parties on the direction they see the company going, that can, those are I would call them the easier ones to resolve than when there's what we would call intentional acts that would be deemed as, like I said, embezzlement, waste of corporate assets, failing to make distributions, although one party's taking it. Those get tougher. And that's why if you have all this information, it makes it a lot easier. So I always encourage, and I do it, I encourage anyone who mediates these types of disputes, you want to share that information with the other side and get it to the mediator before the mediation officially convenes in terms of everyone being together. Because without that, you're going to really be running in a rut. You're going to have a lot of people. The last thing you want is saying, hold on, let me call the CPA. Hold on, let me call accounts receivable. Hold on, let me call accounts payable. So preparation is really a key area. I would say that in this type of mediations, it's probably what your ability to succeed in settling the mediation, and I can't emphasize it enough, is what's taking place before they officially where everyone sits down together to actually try to resolve the case. Because like I said, if it's incomplete or inaccurate, you're probably looking at an adjournment or coming back because people are just not going to spend give up monies, give this up, give that up if they don't know what they're getting. Um, Different types of outcomes that you see. It may be a stock redemption where the corporation buys the stock back, buys the interest back of one of the parties that's looking to walk away. Sometimes that's what they want. Maybe they just have had enough. All of a sudden, they're in a business and they say, I don't want to do this anymore. I want to retire, or maybe I want to try a different career path, or I'm just burned out. I don't want to do it. So in that case, when there's a buyout situation, generally a bit of an easier mediation and easier to settle because then you're talking numbers, right? The bigger issue comes when both parties say, I want the company, I want the company. Okay. And that's where you're going to have to really dig in because how do we split this company up? There may be fights over key employees. Another benefit, by the way, to early mediation, employees, I mean, everyone hears the water cooler talk. If myself and, I'm just going to pick on Shari, if Shari and I are partners in a business and, the employees start getting nervous and say, uh-oh, Gary and Shari, what are all these closed door meetings and why do we hear yelling behind the doors?
How
And
could
what are
that
all
ever happen with us,
Yeah, correct. That would never happen with us, right, Shari?
Gary? Right.
Okay. So what happens is, listen, people have that sixth sense, right? You're in your office, all of a sudden, a lot of closed door meetings are going on. You hear yelling, or, you walk in the morning and two or three of the principals of the company won't even look at each other. It's a little odd, right? If all of a sudden, for years, they've always been buddy-buddy, and now all of a sudden, they're not even looking at each other. Employees get that feeling. And what happens is they're saying, uh-oh, maybe time I jump ship, which means valuable employees, key assets, key people are going to say, I'm not sticking around for this. Okay. So when you are actually, one of the ways when you're dividing up a company is perhaps what happens is, a list of clients. Who brought in what? Whose client is this? Whose client is this? Or if it's a client that, for some reason we can't agree on, is there a buyout on that? Are we going to split distributions going forward? I will say one of the big ways that these can be avoided, okay, is when you have an operating agreement, a shareholders agreement, a written agreement between the owners, principal shareholders, as to what happens when if a dissolution takes place. Okay. I can tell you I've mediated many cases where, couple of people out of college or, they were young, they start off or forgetting age, they start a business, say, let's see where it goes. I did one quite some time ago. Two college students started a business. And what turned out to be, I guess we'll call it drinking money, book money, whatever you want to call it, ended up turning, by the time they were 30, it turned into a $20 million business. Okay. How many operate, how much they had in writing about their agreements and what would happen on succession or anything else? Zero. They had nothing. They started off with a handshake. And their answer was, we never thought it was going to get like this. We thought it was a great way to pay for books, pay for dates, pay for drinks, and, some spring breaks. Next thing they know, they're sitting on a $20 million operation. Shari, do you have your hand up?
Yes, I just wanted to say, and I think it doesn't cover every issue, especially the ones that you're describing, but in the event that there is not an operating agreement, the Florida statutes have an LLC statute, which basically is, this is your operating agreement if you don't have an operating agreement. And, corporations, this is your operating agreement if you don't have an operating agreement. And it doesn't exactly work like that, but it does say, this is how you do, this is how you have meetings. These are what your requirements are. These are your duties and of loyalty, et cetera, et cetera, et cetera. So interestingly enough, even without a document, there's statutory guidance, but like you said, I mean, it doesn't go deep enough for these kinds of scenarios.
No, correct. And you beat me to the punch. So here's where the problem comes. You beat me right to the punch. So Shari gave the prelude. Here's the problem. Now you're going to the Uniform Revised Limited Liability Act. You're going to corporate laws, the Florida statutes. And what's unfortunate is sometimes, look, it's like, if a couple, if people die, without a will, there's an elective share for one of the spouses, right? There's an elective share. If there's no will, if they die intestate, there's an elective share. What are we talking about? We're talking about default mechanisms, meaning if you don't have these agreements ironed out when you're in a business, starting a business, or as the business starts to grow, and you don't start thinking about this, what's going to happen is, to Sherry's point, and like I said, she beat me to the punch. Now, where do we go? Now we got to start falling back on statutes. And people don't always like that because, the statutes say what they say. And if you don't have anything and it's going to end up in court, you've got statutes that may dictate how this is going to go. Okay. And instead of having it set up where succession plans, who's going to come in, who's not coming in, how a dissolution would break up. Well, now instead of you and your partner having negotiated this and putting together a comprehensive agreement as to what happens, because it's always the same thing. When there's no agreement, it's always, well, we never figured that this would ever happen. I never figured that, me and my sister, me and my brother would have a falling out like this. I could never figure me and my dad. That's unfortunately, with the technology today, I've mediated those. All of a sudden, the kids want to go and bring the company into, the 22nd, 23rd, 24th century. And mom or dad may be saying, this company ran perfectly fine on, for those of us old enough to remember, the carbon paper writing through, and it would make a copy underneath. Why are you, what is this that you want us to do a $1 million upgrade on our technology? Why would I do that when the company's been operating and been profitable all these years? And you'd be surprised. Sometimes it becomes a very big issue for family. The biggest issue I see where these get triggered, though, is generally in a family business, is when a parent or the parents that started the company pass or decide to retire, and the siblings come in, and there may be a very different opinion as to how this company should run. I see that quite often. That's usually a good trigger to a business divorce. Again, one of the other areas, unfortunately, is, as we all know, everyone is human. You're going to see the accusations of embezzlement, breach of fiduciary duty to one another. Is it going to become a derivative action where one shareholder says, I'm going to bring it on behalf of myself and the corporation? These are all things to consider in terms of how the mediation goes, what type of outcome are you looking for? So again, one of the other big issues is for the attorneys ahead of time. And if they don't, you reach out to the attorneys and say, what is it that your client is ultimately looking for? I've done mediations where I'll just pick on someone I see, Richard Perlman. Richard Perlman may say to me as his attorney, listen, here's what we're going to do in this mediation. Until the very last minute, you're going to tell them that I want half the business. I want to keep the business operating. And we're going to see how, because I know my partner wants it bad. And then when we get to the end, after we've worn them down, then we're going to throw a number to buy me out. So what is it? It's a bluff. Okay. And listen, that's what happens. We all know, it's like the first round of a mediation. You can throw usually the first round, you throw the numbers. They just don't mean anything till you get to the third round, until you're getting in a little bit, you don't really see where the numbers fall. But those are the type of things for a mediator that helps, because in this area of law, when I mediate these, when I litigate these, and I mediate these often, I still litigate them. It's about preparation, because the faster you can shut these down between the partners and reach a resolution, it's better for everybody involved. Because again, I know when I've been appointed a receiver, no one ever welcomes me with open arms. Okay. especially when I tell them, they say, well, we have a CPA. And I go, I know that's nice, but the two of you, neither one of you likes the CPA, one doesn't. So guess what? I'm going to find my own CPA. I have to sell your building. Well, guess what? You don't agree on the realtor. You don't agree. You don't agree on the valuation. You don't. Now I'm going to get my own appraiser and real estate broker to handle this. And a receiver has that ability to do it. When a receiver comes in on a business divorce, those orders gives a lot of latitude for what the receiver can do. And to sue a receiver, if you don't like what they're doing, you need to file something what's called a Barton motion, which means you now need to go get permission of the court to sue the receiver. And I can tell you, those are not easy motions to win on. And you can think of the practicality of it. If receivers were just able to be sued like this, I don't think you'd have people acting as receivers. Okay. So, generally speaking, when that receiver comes in, they've just taken over your company is really what they've done. I mean, it's not even, it's not that they, it appears that way. That is what they've done. They're going to start reporting to the court with whatever interim reports the court requires. Distributions are going to be up to the receiver. They've become the new CEO of your company. So the different outcomes like I said, can be a stock redemption. It may be a dissolution. Maybe the partners have just had it and said, you know what, let's go to a judicial dissolution. Let's just get rid of this and end it. No receiver. Let's just go through a judicial dissolution, get our assets, liabilities, pay everyone off, and whatever's left at the end, divide up, or we can fight over apportionment at the end. But even those, easier to work it out in a mediation than it is to go through the courts. Because if you can do it through a mediation, again, we all know certainty over uncertainty, right? Because you never know. Jury, judge, you never know what's going to happen when you actually go in. And I tell my clients that when I'm litigating, I can do everything in the world for you, but there's one thing I can't do. I can't, unless you're Karnak or Kreskin, I can't crawl in the head of 6 people or into the head of a judge and say, this is what, I don't know what it is, especially a jury. I don't know what it is that may or may not tick them off or catch their, what it is they're latching on to, what a judge thinks is more important. My interpretation of something may be different than it is to the judge. And if the way the judge interprets it, ultimately, if it's no jury, it's going to be a bench trial, or it's going to be all the way through the judge is going to make that determination. So, look, I could look at a case, I could look at one. Eric Hyden and I could both look at the same case. He could say it says that on this, the sky is blue. I could say, I don't really see it that way, Eric. I think it says the sky was sort of royal blue. I mean, that's how we all make a living, right? When we're as lawyers. But is anyone have any, Megan, I don't know where I'm at time. If anyone has any questions.
We're right at time, but yeah, we'll take any questions before we move on to the second presentation.
And I apologize for speaking so fast. It's just a lot to get out there in 30 minutes. So I apologize.
No, that was great.
You did a
great, Gary.
fantastic job.
Yeah, thank you for all the insights. I appreciate it. We'll if we see any questions pop up, we'll take some at the end. But let's move on to our second presentation. We have therapy speak and mediation. Oh, thank you, Gary. Gena Abel-Barnes is a licensed mental health counselor, certified clinical trauma professional, and Florida Supreme Court certified county court mediator. She earned her master's degree in counselor education and a certificate in marriage and family therapy from the University of Central Florida, where she also completed her undergraduate studies in psychology. With over a decade of experience, Gena has supported individuals, couples, and families navigating trauma, relationship challenges, anxiety, and depression. Her career spans diverse nonprofit and clinical settings, including inpatient hospitalization, crisis stabilization, community mental health, substance abuse services, and diagnostic assessment, where she has built a reputation for creating a safe, compassionate, and culturally responsive therapeutic environment. As the daughter of Caribbean immigrants, Gena brings a deep understanding of the cultural needs of Black, African American, and Caribbean communities, offering evidence-based, culturally sensitive care to Florida residents of Caribbean descent. Thank you so much Gena for being here. I know this is something that we've heard a lot about recently, this therapy speak. Apparently, everyone is a narcissist now. So I'm looking forward to hearing what you have to say on this topic and take it away.
Thank you so much. Good afternoon, everyone. So about 2 years ago, I was facilitating a multi-session mediation between a couple that recently broke up and they're trying to split their property and their assets. During one session, I will never forget it. The young woman said to her ex slash me, while she was talking, she was saying, "You are such a narcissist. This is exactly why we broke up." Then she was saying that he's been gaslighting me basically for as long as we've been together. So the guy, he scoffs and he says, "And that's what I mean when I say that you're borderline." I froze. I was like, OMG, what in the world is going on? It had already been heated, but this was a little bit more than I had anticipated for that particular session. So here's where the problem is. People now use therapy terms everywhere, but they don't always understand the concepts or the correct definition behind those terms. So today we're going to review some of the most commonly misused therapy terms, get their correct definition and meaning, and give you real-world application tips of how to manage your mediation session without getting bogged down in therapy speak. So as Megan shared, my name is Gena Abel-Barnes, and I'm the owner and founder of Able Counseling, Consulting, and Mediation, where I serve as both a mediator and a therapist. When I have my therapy hat on, I work to remove trauma from the body with my therapy clients, which includes a lot of emotional regulation skill building, techniques that promote neuroplasticity, and I help them release their trauma through somatic practices. As a mediator, I'm facilitating that productive communication, helping the parties to manage their emotions so they can hopefully get to resolution. So let's talk a little bit about the social media psychology phenomenon. So why has therapy speak exploded? So with social media, everyone has a voice and a platform. This is awesome that everyone, has the way to share their voice, but it also has drawbacks. So TikTok, Instagram, Facebook, they are full of pop psychology content. So some of the good parts about that. Increased discussion about mental health related conditions and treatment help to reduce stigma, increase awareness, and make learning about conditions and treatment options easier and more accessible for those that are needing help. The problematic parts is that people misuse mental disorders and diagnoses as weapons to try to discredit and put down others. There's oversimplification of complex and nuanced treatment options. And just like armchair quarterbacking during football season, there's armchair diagnosing from those that aren't professionals. So as attorneys, how many of y'all have seen videos online of people sharing legal information and they don't have the credentials or the knowledge to fully understand the topic and what they're talking about? So how does all of this relate to mediation? The pop psychology terms are now showing up in mediation sessions, depositions, and court filings in ways that interfere and muddy up the judicial process and the dispute resolution process. So let's get the real deal on some of these diagnoses and conditions. The first one, narcissism. This is a big one that we hear nearly every day. 5 years ago, I only heard about narcissism within the therapy circle. Now, if I'm scrolling TikTok, every 2 videos, someone's talking about someone being a narcissist. So here's the real information. Narcissistic personality disorder, NPD, is one of 10 specific personality disorders in the DSM. The DSM is the authoritative guide for diagnosing mental disorders. So therapists use it, psychologists, psychiatrists, psychiatric nurse practitioners. This is what we use for diagnosing mental conditions. And a personality disorder, super quick, that's an enduring pattern of inner experience and behavior that deviates markedly from the expectation of the individual's culture. It's pervasive and inflexible. It has an onset in adolescence or early adulthood. It's stable over time, and it leads to distress or impairment. So what all that means is it's not wavering. It doesn't just show up one day out of the blue and the past 5 years was fine. And it causes distress for that person. So here's what some people think NPD means. Someone who's selfish, mean, or self-centered. Anyone who hurt them and they won't apologize for hurting them. And that's so much of what we hear on social media, where people will say their former partner is a narcissist, or someone they don't like has a personality disorder because they're mean. They call them all kind of bad names and they're lacking empathy. So here's what it actually means. The essential feature of narcissistic personality disorder is a pervasive pattern of grandiosity, need for admiration, a sense of entitlement, and a lack of empathy that begins in early adulthood and is present in a variety of contexts, not just in your romantic relationship, for example, but in many different places. There are 9 different criteria points for this condition, and a person needs to meet at least 5 of them for this condition to be considered. So it's not just, hey, they did 1 or 2 things. There's a whole criteria set they have to meet to receive this diagnosis. So what it looks like in real life. Individuals with this disorder believe that they're superior, they're special or unique, and expect others to recognize them as such. Individuals with this disorder generally require excessive admiration. Their self-esteem is usually actually very fragile. Excessive pride in achievements, a relative lack of emotional display, and disdain for others' sensitivities is a hallmark of this condition. So in social media, what things do we hear and see all the time? Red flag videos, 10 signs that they're a narcissist, and behavior clips that show bad behavior, but there's no context behind it. It's showing some guy, for example, doing something that's not great, but we don't know what's going on. The other person looks awful, but we have no context of what's happening. Sometimes, as we have seen in our lives, people are just mean. They have horrible emotional regulation skills. They have very little empathy for others, or they don't care about their partner. That does not mean that they're a narcissist. So overall, personality disorders are easy to say, but are very challenging to diagnose because meeting the diagnostic criteria is based on not only client report, sometimes family and friends can provide input, and the diagnostic criteria, they are complex. So in mediation, what do we do? This label of being a narcissist or dealing with someone that shows these behaviors can derail negotiations for a few different reasons. It puts the other party on the defensive because their feelings and needs are actively being shut down and not considered. That narcissists, they believe that they are special, they're unique, and have a grandiose sense of self-importance, and little work can be done in this space sometimes. So what do we need to do? A few different points. We need to redirect the conversation. And how do we do that? When you hear one party say to the other one, oh, they're a narcissist, one question you can ask is, help me to understand the specific behaviors that are concerning to you. This helps to give concrete examples that aren't rooted in their feelings, and it prevents them from sharing a diagnosis the person truly may not have. Getting examples also helps you to anticipate future concerns that may arise due to their behavior. So ask for specific examples and reframe into actionable items. It sounds like you're saying trust has been broken due to their actions. Let's talk about what repair looks like in a tangible way. So reframing into actionable items and redirecting the conversation. Let's take a moment to talk about attachment styles. So people think this is like a personality type, like a Myers-Briggs personality test, but for relationships. And some people say it's an excuse for behavior that might border on being problematic. I can't help it, I'm anxiously attached. He and I weren't compatible because I think he's avoidant and he has that attachment style. He's close with his family and friends, but struggles to share feelings with me. So a fixed trait, some people think it's a fixed trait and there's no way to change it, and all of this is incorrect. So what attachment style actually means. So psychiatrist John Bowlby proposed this attachment theory in the 50s and 60s, and psychologist Mary Ainsworth later expanded on this theory. So attachment theory defines how the quality and accessibility of the parents impact a child's sense of safety, security, psychological development, and their health. So it's formed in early childhood, but can shift with experiences and relationships. And attachment styles show in all different types of relationships. So romantic, professional, family, friends, neighbors, not just your romantic partner. So what it looks like in real life. Much of attachment style concerns develop due to emotional and behavioral inconsistencies in parents and caregivers. So now as adults, they feel the connection feels unpredictable. What once may have felt secure becomes distant, and communication sometimes is followed by silence or inaction. So in real life, knowing your own attachment style and corresponding behaviors can help you address shortcomings and improve your relationships. Therapy is a great way to identify your attachment style and actions to help address concerning behavior. Social media can be super problematic when talking about attachment styles. You'll hear something like, one anxious attachment paired with an avoidant attachment style automatically means that you're in a toxic and unhealthy relationship. It won't work. No, no. You'll also hear it shared as oversimplified matchmaking advice. If you have this attachment style and this attachment style, y'all are a match made in heaven. If you have A and B, stay away from each other. You'll hear that, but that's not how things work. In family mediation specifically, you may see this come up frequently when parents try to weaponize this. The other parent has an avoidant attachment style and they shouldn't have custody at all. Since I have a secure attachment style and she has an insecure and anxious style, she shouldn't be raising our kids. So does someone's attachment style automatically mean they'll be the best or the worst parent? Absolutely not. But some people will share what they think the other style is to discredit them. So there can be big dangers when parties try to use attachment style as their reason for supporting their custody request. So here's what to do in mediation before and during when you hear about attachment styles. Acknowledge the underlying fear or need. Are they concerned that emotional and behavioral inconsistency from their partner or themselves may be passed on to their children, which will continue that problematic style? Is that one of their concerns? Is the marriage dissolution and/or time-sharing process bringing up feelings within them of rejection that they experienced when they were a kid? Can this somehow be included in the parenting plan to help ease those concerns? So acknowledge the underlying fear and redirect the parent's behavior to the parent's behaviors to the child's needs. So this is 100% about the child and their best interest. We know too often, it's the parents that are causing a lot of the issues and the child is left and their needs aren't being considered. So redirect their parenting behaviors to focus on the child's needs. Attachment styles are not 100% fixed with no option for growth because early intervention is key. One additional step to take is to encourage support for parent and child. So this can include therapy, parenting groups, and social support for the kids to help develop a healthy attachment to the adults in their life. Parents also need social support to work on being a well-rounded parent. So let's take 30 seconds to do a super quick activity to talk about neuroplasticity and pattern interruption. So I want everyone to take their hands and just fold it together. Just real quick, fold it together, interlace your fingers. And I want you to take a notice to see which thumb is up, which one is on the top. Now unfold and switch it up. Now that feels completely off. Ain't nothing uncomfortable about that. Now you're thinking about your hands. You feel your hands like something doesn't feel right. That's uncomfortable. So this is your brain's established neural pathway that's being challenged. And so this is what happens when someone that's practiced a narrative for months or even years before mediation brings that story into mediation. My ex is a narcissist. She's crazy and bipolar. They have a particular neural pathway, how they normally clasp their hands, that is set, and they use the mental health condition to disparage the other partner in almost an ingrained way. They're so used to this, and they've practiced this statement for so long, this is natural to them. In mediation, we're asking people to interrupt that pattern and try a different way of thinking. It's uncomfortable, just like the wrong thumb being on top, but it's possible for them to try a different approach. Our job isn't to convince them that their narrative is wrong. We're not here for right and wrong, but to help them to hold space differently and to have different pathways that might serve them better as they're trying to resolve this dispute. So, super quick debrief. When someone comes in armed with labels, they've practiced that story long before they came to mediation. They've practiced in their head 100 times what they believe their partner to be. Combine this with elevated emotions, underlying anger and resentment, and overall frustration, that can lead to challenging mediations where diagnoses and conditions are thrown around like a football during Super Bowl. So in the mediation room, we are not therapists. Even though I am a therapist, during my opening statement, I let the parties know, yes, I'm a licensed therapist. However, during this time right here, my therapy hat is off, my mediation hat is on. So we're not therapists in the mediation room, but we utilize a lot of therapeutic skills to move towards resolution. Active listening, paraphrasing, reframing. We can still recognize we're asking them to do something that feels uncomfortable. It'll take time to become more comfy, but that's all part of facilitating communication during mediation. So a few quick common terms, a quick hits on some common terms. Gaslighting. Everyone's being gaslit in this world, apparently. I didn't know what's happening, but apparently everyone's being gaslit right now. So it's often misused for any disagreement. What gaslighting is manipulation techniques where a person tries to convince someone that their reality isn't true. So how to manage that during mediation? As a client, if they feel like their reality is being distorted, ask for a private caucus. The client can ask for a caucus, or you can, of course, break into caucus. For family disputes, acknowledge the concern and redirect to the child as the main focus. I hear your concern about how decisions are being made regarding your son, Brandon. In custody matters, my focus isn't on diagnosing either parent. Can you give me a specific example of a recent situation where you felt his needs weren't being considered? Move away from what they say the behavior is, focusing on the child. In business disputes, redirect from personal attacks to the business interests. Focus on quantifiable damages and asset division. Acknowledge the pattern of problematic behavior without validating that diagnosis. The big question in business disputes, who gets what is it worth, and who's going to get it? Toxic. Everyone is also toxic. We're gaslighting everyone. Everyone's also toxic. This term is very general. It's vague. It's inflammatory. It doesn't share any details of what's going on. So once again, acknowledge and recognize the pattern without validating the diagnosis or the character assassination. Trauma. Not every bad experience is trauma. I know as a trauma therapist, not everything is trauma. Trauma is an emotional response to a terrible event that makes it difficult to cope. So one thing about this, especially in mediation, is as you're listening, if you're hearing that someone might be discussing a traumatic event for the first time, they're becoming very emotional, request that caucus, separate the parties. Show empathy, because past trauma could be the exact reason why we're in mediation. So you want to make sure that the person isn't having to relive that trauma in the mediation room, but showing empathy is super important. Boundaries. Is everyone setting up boundaries and protecting their peace? Not everyone. Some people are actually putting up walls. They're avoiding accountability and letting relationships perish in the name of protecting their peace and setting boundaries. There are definitely healthy versus weaponized boundaries, and some things make you think that they're boundaries when they're actually not. So what do we do? Acknowledge the need for safety while reframing peace as the goal through resolution rather than avoidance. So sometimes we need to do some reality testing. Pointing out that protecting your peace through silence may lead to external decision makers, like the judge, for example, imposing a much more punitive or undesirable a resolution. So whatever you can get done here in mediation is going to be your best bet. In mediation, when someone uses therapy speak, don't agree with the diagnosis. You may have the details, but don't say, oh yeah, I agree that she's this, or I agree that he's that, because that can create alliance issues. So you want to translate the behavior. It sounds like this particular behavior has been really harmful. Help me to understand how that's impacting this dispute. Reframe the needs, and also reality test the appropriateness. Is this relevant to the dispute, or is this person just venting? I hear your concern about X, and I want to ensure I understand your concerns. So there are a few different ways in the mediation to not validate that, this person said they're borderline, and yes, I agree. We're not trying to validate that. We're trying to get some concrete information so we can use that to move towards resolution. In closing, social media changed our lives in a great way, but also in a harmful way due to everyone having a platform to share their opinions and ideas, especially if their ideas are not based in science or research.
Hey there.
Yes, social media has given people language without that literacy. Our roles as mediators is to translate, validate they have concerns and their lived experience, but not reject who they are and what they're saying. The goal is to move from labels, which are personal and inflammatory, to behaviors and needs. You can also empower them. You now have a framework to navigate this increasingly common challenge. So these terms have entered our mainstream vocabulary because people are hungry to understand themselves and others. Our job is to honor that hunger while keeping the mediation process productive. Thank you.
Thank you so much, Gena. I think, Sherry, at one point you raised your hand. Did you still have a question?
Well, it's funny. I was just going to circle back to some of the things that Gena had mentioned about how when people raise these issues, what sort of the best thumbnail tactics of redirecting it. And I think she actually summarized that at the end. So I caught myself being ahead of her essay or her explanation.
Awesome. And then I think there was also another question, Gena. If you're comfortable, are you willing to share a copy of your PowerPoint presentation?
For the right fee, I can do it. But since I'm with this group, I'll definitely share it for free. No problem.
Sounds good. And I see that you put your email in the chat. So anyone that's looking for that, just go ahead and reach out to Gena and she'll get that information over to you. Thank you so much. That was really informative. Thank you, Gena and Gary, both of you, so much for this excellent presentation, and to all of you for participating in this lunch and learn provided by the Alternative Dispute Resolution section. I know we've had all of the information about the programs going in the chat. I added registration links for our upcoming lunch and learns and CLEs and all of that. So feel free to scroll through while we're closing out here. But just for the people who might be watching this on the recording, I'm going to say the titles again, the CLE numbers, and what the credits count for. For CME reporting, you're just going to need to have the title, the speaker's name, and then it's a half CME credit for each of these, and then also just the date of the program. So today is March 13th. So For Gary's, we had preparing for a business divorce mediation, and that is from Gary Rosner. It's 0.5 general CLE and 0.5 business litigation, and that is CLE number 251705-2N. And then we had Gena Abel-Barnes with Therapy Speak at Mediation. That one's going to be 0.5 general CLE and 0.5 professionalism. And that is 251705-3N. And thanks to the Dispute Resolution Center for processing all of this CLE for us and doing this Lunch and Learn series with us in collaboration, because it allows us to bring you guys free programming and CME credits. So we've still got a few more to go in the series where we're going to go over a variety of topics. I know I need some tech credit, so I'm really excited for June or May. I think it's May, where it's going to be a whole hour of tech. But we hope you found this program insightful, and we welcome your feedback through evaluation. Feel free to reach out to the section. It's flabar@gmail.com, and let us know what you'd like to see in the future, what you enjoyed about this program. And then coming up, we have on March 18th, our Arbitration Advocacy Institute. And on April 2nd, we have CLE Justice on the Spectrum about neurodivergence in mediation in the law. We also have our mediator forums every month on the first Friday at 8 a.m. And we have arbitration forums on the second Tuesday of every month at 8 a.m. I think the arbitration one is changing a little bit in April, so keep an eye on our calendar for that one. And the next Lunch and Learn is April 10th, which is the second Friday of the month. And the rest of the series, they'll be the second Friday of the month, all the way through June or July. So we hope you'll join us. We invite you to join the ADR section to receive access to more quality CLE courses and the latest news on dispute resolution processes. Thank you again to our annual section sponsors, Miles Mediation and ADR Notable. And thank you for being with us today, everyone. We appreciate your collaboration with the section.